sends me over the contract. We reviewed the contract, and unfortunately, like, it was one of those contracts that wasn't suited to the situation that he was trying to resolve, that they had downloaded from the internet and was kind of right, but not right. And so I went back to him and said, I'm glad you have something here, but this could eventually become a big problem. And he's like, I really don't want to go back to my co-founder and say, hey, and by the way, we're doing really well and we're about to raise X millions of dollars, but I need you to sign this document, right? And I'm like, I get it.
Hello, everyone. Welcome again to another fantastic episode of our Fearless Founders Club podcast. And we're excited today to have a dear friend of mine, Josh Freeman. Josh and I have known each other for a long time. I just got to know him as we were getting acquainted before turning on the record button. But Josh has started a business that has exclusively helped, from a legal standpoint, all of the innovators and entrepreneurs, and he has taken it from a small shop when I knew him with 4, 5 maybe partners to over 38 plus and a staff to support that of legal partners. So his focus is on helping the entrepreneur succeed. So isn't he perfect for this podcast? In his innovative law firm that he started, Freeman Lovell, he's also been an expert in helping guide these companies from not cradle to grave, but from start to exit, and has even started this last year a new company called Exit Engine. And this Exit Engine is particularly focused on helping those businesses maximize their value so that there comes a time when it's time to sell and exit, it's on their terms. So Josh, we're really excited to have you here. I'm grateful that you can spend a bit of time. And please tell the audience a little bit about yourself at this time.
First, I just want to thank you, Binoy and Ike, for having me on this podcast. I love it. Super excited to be part of this. I totally align with what you're trying to do and empowering founders, helping them be fearless, because the entrepreneurial journey it's tough. It's not easy, and there's a lot that goes into having a really successful business. A little bit of my background: I started Freeman Lovell. It's been 8 years now. Bino, when we met, I think it was only 3 partners. I think it was me and my original partner, Steve, and our first edition when we first had lunch and started getting to know each other. We've seen a lot of success and a lot of growth, and it's been a really fun and also challenging thing to grow it to where we are now. What we wanted to do is we wanted to create a law firm that was built by and for the entrepreneur. We wanted to have founders who were entrepreneurial in nature, who understood taking risks, who wanted to grow their own legal business and do those things, because we think people like that are better suited to provide better legal advice for entrepreneurs who are going through those same types of things. And we also noticed that, in the market, for small private businesses, there are very few law firms that really focus their services around supporting that specific client type. You see really big law firms that are very good and have big teams and tons of resources and focus their representation on publicly traded companies or, seriously funded series, CD, startups and institutional investors and things like that. And you see smaller, like regional or smaller law firms that have legal teams that are a little less focused on, the specific business type, or, different legal needs, and have a criminal guy and a immigration guy and a business guy and different things that way. And we wanted to kind of, marry both worlds and create a firm that was built for the founder, for the small business and entrepreneur, to help them, you know, secure what they have, be able to scale it, and ultimately find an exit, and, be able to become and do what they want to do with their businesses. And so, yeah, been at this, been at it with Freeman Level for about 8 years now. My practice primarily focuses on helping, businesses find the right structure, um, scale that structure, and then sell their business. I've worked with thousands of business over the, past 7 years, and have seen good and bad, and success and failure, and everything in between. And it's just an honor for me to be, part of the team with these founders as they go through the process of trying to turn their business into, something that can change their little corner of the world. So that's a
It's
little background
fantastic.
on me.
Yeah, it's fantastic to know that there are some talented, caring people whose expertise is in law for founders. Doesn't that just make you feel like, oh, somebody cares, right?
And I also understands like for you to be an entrepreneur yourself, right? I think,
Yeah.
and then your partners are also in that same cloth, right? It makes a big difference.
And
Yeah, absolutely.
particularly when founders, we're all trying to figure out, how do I go forward? Yeah, I've got a great idea, but I don't know if I've got the right things put together. And clearly, there are many who come to you, and you've said this multiple times. Maybe two things you could say right now off the cuff. Josh, over over all of these years, what have you noticed people do consistently, right or wrong, that is advice? You just here's what I see all the time. What would be the advice you'd give?
Well, that's a great question. I think the the businesses that do it right are the ones who have the courage to do things right. And what I mean by that is, I'll have businesses that'll come to me, and they'll have, difficult problems that they're trying to solve, both as a business, and have challenges within their business, with whether it's a like co-founder disputes, or other, issues with like major suppliers, or other things like that. And, the ones that I see can be successful are the ones when we sit down and we talk through the challenge and say, I know this is going to be difficult, but we're going to have to go back and fix some things and change some things. And it might slow you down for a week, but this is what has to happen in order for you to be able to grow. We can't just brush things under the rug, or hide the skeleton in the closet.
Can you give
Um,
a specific example, it doesn't have to be identifying anybody, but can you give an example of that so people can relate?
Yeah, absolutely. I think one of the biggest problems from a legal standpoint that happens are, I had a client come to me a little while ago and say, "Hey, a year and a half ago, I broke up with my co-founder, and he left the company, and he signed this contract, but we need to bring on some investors, and we need to do some things that way." And so I'm like, "Hey, that sounds great. We need to start and make sure that like everything's clean and good and ready to go." And so he sends me over the contract. We review the contract, and unfortunately, like, it was one of those contracts that wasn't suited to the situation that he was trying to resolve, that they had downloaded from the internet and was kind of right, but not right. And so I went back to him and said, "I'm glad you have something here, but this could eventually become a big problem. And he's like, I really don't want to go back to my co-founder and say, hey, and by the way, we're doing really well and we're about to raise X millions of dollars, but I need you to sign this document, right? And I'm like, I get it, and you may be able to get your investors to go along with this, but at some point down the road, you're like, if you're successful, this is going to create a problem and we're going to have to do it. He's like, okay, I get it. And, we sat down, talked through the dynamic, talked through like he what he needs to share, what he doesn't need to share, how to, try to address it, and got him the right contract with the right provisions to make sure that all of the equity was cleanly transferred back to the company and that there were no ongoing claims as far as ownership of intellectual property or any of the code that he had developed or other things that way. And so he was able to do that. It was not fun for him, and we had to negotiate some things and that way, but he you know but he did it. He was courageous, made it happen. There's been a lot of times where I've had clients who weren't willing to do that and just said, you know what, let's just try to get this done, we'll deal with this later, and those those ones typically didn't work out as well.
Yeah, I'm going to go along this thread. There's more advice you've got, but I have seen too many people give too much away in terms of equity and finding having a partner or two or three, and no level of earnout, no level of vesting, nothing. And right now, I'm actually advising a client right now who has 7 partners, and they're all automatically at significant ratios, owners of the business. And now, right now, one of the owners, he had a lunch with him last Friday, and in no uncertain terms said, you are absolutely the worst business partner. I do not like where this business is going, and just told him exactly how unhappy he was. So I'm having lunch. I had lunch with him yesterday, and I said, dude, he's got to go. You cannot have this cancerous entity within your company. But what are you going to do about the equity? Right? This happens too frequently, Josh. Do you see this?
A ton. Oh yeah, all the time. Yeah, all the time. And that's and that's why, like, getting, like you said, have vesting in place, so people have to be involved for a while, contribute, do those things. Super important. Making sure that, like, one of the things that we talk about with our clients up front is we want to make sure that the company controls the cap table, and that the company has the ability that if a partner doesn't fit or if an employee isn't working out, that you have the ability to repurchase equity, that there are mechanisms so that you can keep control of that, because that is a huge problem. And just a few months ago, there was a scenario like this where I had a client come to me similarly, where they had a founder group of, I don't know, I think it was like 7 or 8 people, each with like 15, 20, 25, in that 10 to 25% range, sort of a thing. And the investor is like, this isn't going to work. There was no vesting. We've got to put vesting on all of the founders. And, and we need to look at rebalancing some of the equity through some option grants or some other, other equity grants, because it wasn't well aligned for like the future growth and to allow for like clean control and other things that way. But yeah, that's absolutely something that needs to be thought about early on, and regardless of how well you know each other, how much you like each other, how good everybody is, having at least some significant portion of equity needs to be vesting on,
I see a lot of founders being very savvy to protecting the IP. They understand they have some gold nugget But what gives more headaches is the relationship with the original group or successive groups of people that are brought on at a senior enough level that they are enticed, particularly since this is a startup. They don't have the money, so they're going to give, a form of compensation that is going to be meaningful, and that's where it gets screwed up. Almost always gets screwed up. And
Yeah.
I think
so
I think I think like having no money is is the top of the mind with the founders, right? Like that drives a lot of decisions, and probably they don't get the right help they need, like someone like you, Josh. I remember from my experience, like when I was bootstrapping, cash was the king, right? We had somebody part-time, reduced price, reduced fees in exchange for some options, right?
Mm-hmm.
And then when the Series A came, the Series A firm had 5 legal counsels on that side of the table, and I had this part-time guy, like, hey, I've done a few Series A's before, but I'm cheap. And then after the Series A, we upgraded, like we found some company like Josh's, and then a PE firm came for acquisition. They had 17 lawyers on their side, and I had 4. I can never win. Like, so what are your advices, Josh? Like money is tight, but what are the best prices, like, or the thought process they should think about engaging help from you, your friends, or do you know what I mean? Like, while the money
Yeah.
is tight.
Yeah. I mean, yeah, that's definitely like something that so many of my clients are dealing with. And I had a phone call the other day with one of them who's, just about starting up a business, and and he's like, "Have you worked with like Stripe Atlas or Carta or some of these others that create document packages and things like that?" And I said, "Yeah, we have." And and as long as your business type fits within the type of business that those documents are well created for, they're really good documents. And so, like, we talked about that, like, we'll do this regular with our clients, is create kind of a hybrid sort of relationship where we don't necessarily have to control every document. And if the business is one where you can get an automated set of documents through one of those service providers or whatever that allows you to get good documents that have the terms and everything like that, the more of the value will come sitting down and like talking to me while you're filling out the questionnaire to make sure you answer the questions right, necessarily than having me input data into forms for you. And so, it's like, when money's cheap, it's, I think, having a counsel to strategically advise you and have those 30-minute hour phone conversations, or work through some of those things on kind of a hybrid basis, is a good way to keep like your costs and fees affordable while still getting like into the right document package. The biggest problem is when a company is like, sets themselves up like a technology startup, but they're an e-commerce business, and or vice versa, or a service business or whatever. It's like there are different types of entities and structures and vehicles that are better suited depending on what you are, and making sure you get in the right one is more important in a lot of cases than than spending thousands and thousands and thousands of dollars on the lawyers customizing and tweaking every provision, because a lot of times templatized packages, if you're buying the right package for the right type of business, works really well.
Yeah.
So this is I'm really glad you brought this up. What Josh said is so important. After doing my, all my startups, I figured out that what Josh said was right. Even an hour, purchase it. Take them out to lunch, guys, but purchase that kind of upfront guidance from a competent legal professional. It saves you so much more down the road in headaches, even though you think, oh, I don't have money for this, I don't, whatever, I'll just use this tool. download this contract, whatever. In the end, that level of upfront guidance saves you so much more than the so-called shortcut. Let me go cut it, my expense down to minimum, and I'll just get a template. I couldn't endorse that more.
So, Josh, when are we going to Tsunami for lunch?
Let's do it. You tell me.
Yes, that's the right way to go. You're scrappy, but get the advice. And many people out there don't know that a Josh exists. They always think, oh, it's got to be this, this, this. So I'm not going to even go there. But no, you gotta use the expertise. And we're glad that Freeman Lovell exists around here in this community and for other states as well. Anyway, so hey, so that was on that topic of doing it for the right reasons, the right way. What are other disasters that people keep consistently incurring? Just they do it to themselves, mostly out of ignorance, mostly because they're cheap. But that's the world that we live in.
I think that like probably the biggest fatal flaw that I see people make is promising an early investor that they like giving an early investor anti-dilution, like saying your equity will never dilute. You'll never go below 5%. You'll never go below 10%. Because number one, an investor who asks for that isn't an investor you should take money from. It's a bad scenario, and it's short-sighted because you want to see the size of the pie increase and double, triple, 10x, 100x, 1000x, right? And a good investor will get in and continue to invest, but not expect an initial investment will keep a certain percentage. I had a business who was 2 days before signing a 10 million Series A, but could not get a prior investor to back off of his anti-dilution provision that they granted, and went from 2 days from signing to filing for bankruptcy, and the business no longer exists. And that was the most catastrophic thing I've ever seen happen that way. So anti-dilution rights, if anybody's asking for it, be very careful. There are different ways they're done. There are like different types of anti-dilution that come up in venture capital packages that are okay, but like a strict like your equity will never go below X percentage is really bad for the business and growth. And that's one where I've seen the really big problems. The other one is a lot of people, when they're starting out and they're cheap, instead of hiring people as W-2 employees, they hire 1099 independent contractors, and often don't have a good solid agreement. The scary thing is independent contractors are considered to own what they create under those contracts, unless your contract specifically says that it is being transferred as a work made for hire. So if you go hire a developer on a 1099 contract, use their contract that doesn't have 1090 that provision, you may not own whatever that developer is developing. And so I've seen scenarios where we have to go back and be like, we got to have you sign these assignments and do all of this stuff because we're preparing for due diligence. They're like, you may not own a key piece of your software, a key piece of your intellectual property because of that. And so like independent contractor contracts, especially when developing IP, it's crucial that you have that. It's really important for employees to sign those as well. Fortunately, there are some employment laws that help mitigate that issue, but that's another like really, really problematic one that's needed to be cleaned up. No vesting, we've talked about that. I think the commercial, like there's always this balance in companies in their contracts with their customers and clients that comes up, that you're trying to balance the ease of getting deals signed and sales happening and revenue come in the door with having strong contractual protections, right? And so sometime, so like those initial contracts can sometimes, if you err on the side of making them very thin, very non-legalistic, can potentially cause problems for you. Usually that's more of like a future litigation problem, which if you have insurance and things that way, you can survive that. But if you don't have insurance, future litigation can be a business killer because of how expensive it is. And so you gotta be aware of like those risks, and how you're protecting yourself to be able to cover potential costs of lawsuits.
I've got experience personally and many friends where there was always this tension between sales, making sure that the legal channels were sufficiently lubricated to enable revenues to come in the business, while the legal in-house teams, and it could be external, were trying to protect from future worries and litigation and wars from happening. And to a point that me being the business owner, I was a little too heavy-handed in saying, zip it, Josh Freeman equivalent. We got to get revenues in. We have a business to run. Let's go make it happen. And then I would find, to my horror, in helping sales occur, the sales rep at the front level, his VP or director didn't look at everything properly, and there were some gaping holes made in the hurry to get sales to come through. And then we had to have a much more painful exercise in extricating that relationship, because it was not contractually clean and defend or protect our IP. Unbeknownst to us, sales will do what sales needs to do, right?
Yeah.
You
Well,
agree?
and we get it. I mean, we get it. I mean, like sales are the lifeblood of the organization. It has to happen, and it's a problem for the organization if legal's getting in the way of otherwise good deals happening. I think the key is being aware of the issue, and especially as a management team, understanding the trade-offs, right? So taking enough time to sit down with your contract and go, if we get rid of this provision or go with this, modified agreement in this, it'll allow us to contract faster. And this is the risk associated with it. And we're okay with that. And we're going to mitigate that risk by XYZ. That's a great business decision. But the problem is when, everybody's too busy to think about it. And they're just like, legal, stop getting in the way, we're going to do this, sales guy, go have them sign whatever they want to sign, and not understanding at least the risk that you're getting. And so I think it's an exercise of awareness is what's most important.
It's like I've always practiced like it's a business decision at the end, but you need to have the right guides and the advice that people tell you so that you can make informed decisions. You may still go with that. Like I had a situation. It's a very large bank in Southeast Asia. We bought our software. It was like 120K annual subscription, something like that. And they put a clause that said, if this doesn't work and you cause some problems, you'll pay $1 million. Like you should sign this because we want you to make sure that you're not going to damage our business by causing other problems, blah blah, right? My Josh equivalent said, like, why are you even paying more than 120K? So you cannot pay them in penalty more than what you're getting. So we went back to customers and we agreed that we will pay if we cause any damage. We won't, but if we cause any damage, we'll pay up to what you give us.
Mm-hmm.
It was a good decision, but even then, like we were aware of it, we were more careful with this customer than ever, because there's a risk there. But if you don't, first of all, if you don't go back to the customer and renegotiate, that's one problem. Second, if you're not aware of that $1 million clause, and then you one of your support guys makes a mistake because they just woke up and they didn't have their coffee, right? Then you don't put the company in jeopardy.
Yep. Yeah. No, sounds like you got good advice there. So, yeah. Well done.
Yeah.
But yeah, absolutely. You gotta negotiate those things, and and work through that, and just knowing what the issues are, and oftentimes, like something that came to mind as you're talking, Ike, is like, I was having a conversation with one of my clients, and we were negotiating this contract, and he was like, well, what if we did this? And and he provided this very elaborate like approach to a certain provision, and is like, yeah, that's really interesting. And I mean, the nice thing with contracts is we can do whatever you want, but let's step back and talk about like what the goal is. Like, what do you want to accomplish here? He's like, this is what we're concerned about. And I'm like, oh, well, this is how we do it. It's really easy. And he's like, oh, okay. Yeah, I probably should have just asked, like, how do we solve this problem? And, and so it's like having those conversations, and, and proposing ideas, thoughts, but also like goals. You can oftentimes find good, simple solutions like that. Like just, capping damages at, like now one of the common things is we just cap damages at like 1 year's revenues on a certain contract, or, 2 years or whatever, that sort of a thing. It's the same sort of concept. And, you can get a lot really creative, but there's often easy ways to just solve that issue.
Josh, we talked about sort of almost contract, business development, legal help and expertise, but especially for founders, don't you see a lot of them? I certainly needed this help from you for some of my startups. The whole world of trying to figure out, should it be a C Corp, an S, an LLC? Isn't that a basic foundation from which, if properly created, it allows the business to succeed? But we don't know. Most of us founders, we just have an idea. We're going to go sell the heck out of it. We just need to form something. Isn't that something that you also see regularly happening? And what advice would you give on that topic?
Yeah, that's usually like the first conversation that we have with our clients, is to make sure that they have, number one, the right entity type, whether it's a corporation or an LLC, in like some rare circumstances, a limited partnership. And then making sure that that entity is taxed the right way. And so, as a kind of a rule of thumb for people, LLCs are the most flexible. Like if you don't know what you want, but you need to start a business and you want to have liability protection, start with an LLC. You can go anywhere. You can take it to a C Corp. You can have it taxed as an S Corp. You can, do whatever you want, right? And then with like the conversation around C corporations and S corporations, I think the easiest way to remember it is C corporations are for like technology startups and companies that plan to get institutional backing and funding. And then they're also for entities that are looking for an exit within kind of a 5 to 10 year time horizon. Those are kind of the two entities that end up as C. There are two types of businesses that end up as C Corps. And then S Corps are for like consulting, professional practices, services oriented businesses. And even then, a lot of times the S Corp is better reserved for like a personal holding company rather than an actual business operating entity. So like in my case, we have Freeman Level, which is a professional limited liability company. That company we have taxed as a partnership. We, as the operating entity, we don't want it to be an S corporation, but each one of its owners, so myself and Steve, and then our other profits interest owners, we each have individual holding companies taxed as S corporations to be our professional services entities. So there's a, there is a lot that goes into it, and there's different, benefits that come with each. Um, and, but that is, a really important conversation to have, as early on as possible, because some of, if you start as a C corporation or an S corporation, those are hard to get out of and can have adverse tax consequences if you don't do it quickly and properly. There's also time frame things where, if you're looking to sell your business in 5 years, and and you start your company as a C corporation, there's a clock that ticks on what's called qualified small business stock that can save enormous amounts of capital gains tax, for founders and investors in those, if you do that right. And so talking early is important there. So that's one of those conversations where buying lunch or spending a half hour or 45 minutes on the phone, paying your attorneys exorbitant legal fees to just make sure you're in the right place when you're starting a new business, is one where it's well worth the money in the long run.
Yep.
I agree, and you have saved me multiple times, including some of the transactions we've done together. Moving to the next stage, there are partners and founders and co-founders that have some equity play. What advice do you give for any key employees, or as the size of the company grows, do you recommend, have you seen it be good to share in a pool that's for employees, so that people are now getting the latest from you? What's a great practice? What have you seen that really motivates? Because there's still this scrappiness that we all have, and I don't have enough to pay market value yet for the customer success or even the UX designer. I'm waiting for the funding to come in, and so I'm going to give them a little bit. How do you recommend that be structured from an equity pool for the founder versus C-level versus whatever?
Yeah, absolutely. So, I mean, I think one of the things, when I have a founder that comes to me and says, "Hey, I need to hire a chief technology officer," he's getting paid, 400,000 a year right now, but we can only afford 150. What do we do? That sort of a thing. Yeah, I mean, the equity compensation is a huge component of it, and what I see a lot of times is founders often think that they need to give more than what they should probably give up front. So like a lot of times someone will come and, it's like, I think we probably need to give them like 15% of the company or something like that. But a lot of times it's less, it's less than you think is enough to get them there. And especially if you have a company that has a very high potential of value. And, so in technology, especially, those percentages are much smaller. I think, the companies that do it best are, you find an amount, you find the right amount for the type of employee, whether that's a 0.25%, 0.5%, 1%, 5, whatever it is, and you kind of target like this type of employee should probably have about this much. And then I like to see people work their way into it. So if you're like, hey, this is, a chief marketing officer, probably in the 2.5 to 5% ultimate equity range. What I love to see is if, my clients can give them maybe, 1%, have it vest over 4 years, and then and then the following year, if they're still good and still doing their thing, give them the ability to earn another 1%, and so on and so forth. And then that amount incrementally grows over time through like periodic systematic grants that have overlapping and layering vesting that continues to incentivize them being on for a long time, rather than saying, I'm going to give, you new CEO, a chance to earn 10% over 4 years. Instead, maybe do 2% over 4 years, but keep adding it on so that you're talking about a full vesting period of 10 years instead of, for, sort of a thing.
Great advice.
But yeah, I mean, I think that's one of those things where one size doesn't necessarily fit all, because if you're talking about a service business with low, with a much lower ceiling, for exit, then in order to get someone interested, you're going to have to give them more equity than you do in a technology business that has a super high ceiling for value. And so, understanding what your business potential is, what you're trying to do with it, makes a big difference. And and so that's a really good conversation to have, I think, not only with your lawyers, but having those conversations with founders who have gone through it and had good success before, are both like really good people. And if you have good advisors and good investors, advisors to help model that too, that's good. But yeah, like, I mean, setting up a pool, like you said, Binoy, a lot of companies will set up kind of a pool somewhere between 10 to 20% of the total authorized equity that they will give out to as many employees as possible, and having that set aside so that there is a significant portion of the company that's owned by the employees and there to incentivize and help employees, benefit from a future exit, I think is super important.
Do you find that many founders, I was one of them, do not understand the waterfall of equity dilution as successive A round, B round, C rounds happen, and they don't do the math because they're not aware of it, and they don't understand what that means for early family and friends who chipped in money, to angels, then to, right, that whole sequence.
Mm-hmm.
Do you educate? Do you show them what that would be, or is that something that they need to go get prepared elsewhere? Because I think that's crucial.
Or learn the hard way, like me.
Or learn the hard way. Yeah, I mean, so in my role as company counsel, I don't necessarily interact with the rank and file employee who are getting a 0.25% grant of stock options very often. But I was actually having a conversation with my brother a little while ago about this, and saying how, so it's tangential to this, but he works for a very successful technology company and has been there for a very long time in a senior vice president role, and has a lot of options and has bought a lot of stock, but what he didn't understand was like the time period on like qualified small business stock. And he's like, hey, had I understood that, knowing what the business's plans were, I would have exercised my options 3 years earlier to give me a better chance to save on my capital gains tax. But now I'm probably going to have to pay all capital gains because I exercised too late, sort of a thing. And he's like, there should be something that like helps, educate like the employees about these things and how to handle their options and how to handle their stock and everything like that. And I thought that was a really interesting conversation. And I've talked to a number of my clients, and what we have done is we have done like company trainings where we will come in and present on different aspects of the cap table, of how those things work, of waterfall issues, how stock options work and what it means to exercise and what taxes are triggered when and how all of that plays out, and other things that way. I think one of the great things going on now is that like with a lot of the funded companies using cap table management softwares like Carta and Pulley, and those provide a lot more transparency and more information and education, and the employees have easier access to a lot of that information and documents. So I think the technology employees today are a heck of a lot better educated than they were 5 years ago, 10 years ago, with those issues. And especially, I mean, at least in Utah, with the number of successful exits that we've seen with the private companies and employees doing really well from those, there's more. I think there's more awareness now of that, but that's definitely an area where some training can go a long way and can be really helpful for the employees and helping them understand what they have and what they can do to
I,
maximize what they have.
I think the founders needed it more than even the employees. Huh? The
Yeah, that's what I
too.
was going to say. Yes, founders need it as well.
Yeah. I think one of the areas where founders especially need it is the management of safes and convertible notes. I see it a lot of times where founders don't understand exactly how much equity they're potentially giving away based on their discounts or valuation caps on safe agreements or convertible notes that they give to early stage investors. And they just kind of like, oh yeah, it's easy, sign this 2-page safe, and they go and sign them and bring in money. And then they go to do a transaction and they're like, oh wait, I just gave away like Series D type equity percentages in my Series A, and it's a really ugly, rude awakening.
Yeah, if you a friend of mine was asked to do the same, like is it, hey, look, we don't need any due diligence. We can keep it very short. We can just do a promissory note or safe note, right? And then and I was telling him, look, that comes with Josh. You know this better than I do. Like, it's the easiest way for a founder to get money in. The easiest way, the fastest way. But there's a reason for that, because it's not the right way. Right way always is the better. The easiest and fastest way is not only they get percentage, so when the next person comes in and they invest in your company, they get a discount on that. And then if the next, like you said, the cap, if the next person values your company at $20 million, and then there's a cap for $5 million, they're getting 4 times
Exactly.
more shares.
Yep.
Because the safe note had the cap. Like
Yep.
you can't be with it. It's crazy. Like it and the most dangerous one is safe note over a safe note over a safe note. That it's a compounded ways to give away your company.
Yeah. It's one of those. When I talk to my clients, it's like there is something to say for ease and getting that money in, but you have to understand it. You got to run your calculations. You need to
Yeah.
understand what this really means. You need to know what your plan is, because if you don't have a plan, you're like, well, we might raise money, we might not. Like, a safe's terrible, and not understanding, like you said, like if you raise above your valuation cap, that just is a multiplier of how much stock you're giving away. And so yeah, it's something where the ease can be great, but if you don't understand it, you don't know what you're actually doing, and you're not paying attention to it, as you're going and growing, then it can be hugely problematic.
Yeah, Josh, are there other areas that you can maybe share what to look for, what to share? Because I know a lot of startup founders, they did their seeds. They want to do Series A. The money market is tight. The VCs are looking at more details, and now the first question is, are you cash flow free? Not how much you're growing because of the uncertainty. What do you advise for them to look for? I think safe notes is one of them. Just be careful. We're not saying don't do it, but just be careful, right? Like what you're getting into. Are there other things that, like, for a founder that's raising Series A?
I think, yeah, I mean, I think the conversations we have are around what I just said, is like, let's understand what you're actually getting and what you're giving up whenever you raise money. And the other conversation that I regularly have with my clients is, you also need to understand that when a VC invests in you, what does that mean? And then explaining, like, the VC's game is to make an enormous return on a small number of their portfolio investments, make a modest return on a couple of their portfolio investments, and probably break even and lose money on the others. And so if you're going to get on the VC train, you need to be aware that you're going into like a high reward, high risk environment, that even the very best companies with the best teams, have a hard time managing the growth and the stress and the capital management and the economic environments that come up in order to be successful. And so not only understanding like what the investment itself does, but also know what you're signing up for and the type of growth that's expected and what you're going to need to do to keep that specific investor happy and satisfied with where the company is going. Because once you raise money, investor management and managing your resources and your runway and raising additional rounds becomes the full-time job, more or less, of the CEO. And it's not easy, and even the very best can't make it happen the way that people hope. And so I think not only understanding like the specifics of the investment, but also the investment program and what that path to exit actually looks like and what you're signing up for is really important.
Cool.
Question: what percentage of your startup clientele end up not being able to pay for your service?
Luckily, because of who we are and how we set things up, and we operate in a very lean manner, we keep our fees very reasonable, and we have really high collection rates, which is phenomenal for us. I don't think that's the same for big law firms. But fortunately for us, our approach with these kinds of things is, we try to educate our clients on, like what goes into a legal project, how much it's going to cost, what they're looking at, and make sure that they can make a good business decision that the legal services they purchase or have a return on investment for their business. And I think because of that, we've been able to, have really good collection rates and everything that way. We will have clients come to us that are, pre-revenue, seed, totally unfunded, just an idea and things like that. And in those situations, we try to figure out an arrangement that makes sense to make sure that they get the legal services they need. But then as they grow and as they're successful, we also can, capitalize on our sacrifices on our hourly rates and things that way. But yeah, it's always something you have to balance.
I brought up that deliberate goading question to highlight, Ike, that Freeman Lovell is a very rare legal entity, for there are very few companies that are so founder friendly with such flexible payment and creative terms where they are willing to, Josh created this, be actually subsidized later with success as the company succeeds. And I'm a big supporter. And you know that I don't do this, but anyone who's listening or watching this podcast and you're contemplating, what legal service experts to get, Freeman Lovell is whom I recommend. And I have done so, Josh, over the years. Many companies have sent them their way. There aren't many organizations that are built the way he's done it, hence why he's grown so fast. They're not creative enough. And Josh impressed me the very first day. I said, who thinks like this? Especially a lawyer. Right? I'm always teasing Josh on this. Dude, you are so business wise. So much appreciated, Josh. Thank you for great counsel in this tight timeline that you've been able to share some insights. Any questions or items for Josh?
Thank you, Josh. It was great meeting you. Great conversation.
You too. And yeah, thank you so much for having me, Binoy. Thanks for the continued support and shameless plugs for us. I don't know that we're worthy of such, but we appreciate it greatly.
No, you are much needed, and I wish other services companies that support this entire world that we live in thought like you and supported the high risk founders so that they can become less fearful and more fearless. So thank you, Josh. Thanks, everybody. Until next time, just let us know if you have any questions on whatever. and go let Freeman Lovell know that you're in need of their services. Thanks again. Take care, everyone. Bye-bye.